I'm Missy, and here's a peek at the decision in the United States versus Skrmetti, a case that was decided by the Supreme Court on June 18, 2025. Also known as another case that shows why you always want trained medical professionals and not legislators making decisions about healthcare. This case was one of the cases that was heard by the Supreme Court dealing with trans rights and trans healthcare, in this case, healthcare for minors. In this case, the majority in the Supreme Court sided with the state of Tennessee, also known as Skrmetti. The majority opinion was written by the Chief Justice, Justice Roberts, and the major dissent in the case by Justice Sotomayor. So specifically, this case was a decision about Tennessee Senate Bill 1, or SB 1, entitled, quote, Prohibition on Medical Procedures Performed on Minors Related to Sexual Identity, end quote. SB 1 was challenged by doctors, transgender kids' parents, and the Biden administration, who all claimed that this kind of law violates the Equal Protections Clause, the United States Constitution, meaning that it discriminates against transgender kids on the basis of sex in a way that makes them unequal to others, right? And in this case, focusing on sex means that we deal with issues around sex assignment, gender identity, gender expression, sexual orientation, and pregnancy for the purposes of discrimination law. So SB 1, what does it do? And through SB 1, the legislature in Tennessee prohibits healthcare providers from, quote, providing, administering, or dispensing puberty blockers or hormones, end quote, which means providing gender-affirming care. It prohibits them from providing gender-affirming care in this way to any minor, but only when treating certain conditions, namely gender dysphoria. Gender dysphoria is a form of psychological distress that results from a mismatch between sex assigned at birth and gender identity. And it's a condition that, even as Justice Sotomayor notes in her dissent, that is clearly defined by reference to a patient's sex. Also, SB 1 says that minors can have access to puberty blockers, hormones, these kinds of treatments as gender-affirming care when it's treating literally anything other than gender dysphoria, such as precocious puberty. So while you might think that everything about Tennessee Senate Bill 1, or SB 1, including the title of the bill, indicates that this bill was trying to prohibit medical treatments for some minors based on their sex, but not others, the Supreme Court says, no, of course not. And then they write like 80 pages worth of mental gymnastics to prove that this is the case. You don't have to read it because I did. But basically, the majority opinion written by Justice Roberts says that Tennessee's SB 1 is cool because it protects all minors from treatments that are harmful for certain diagnoses. So it protects everyone. So Roberts, writing for the majority, claims that allowing a minor to take hormones is a different medical treatment when applied to gender dysphoria versus when it's applied to treat something like precocious puberty. It's protecting all minors from treatments for gender dysphoria. So it's totally not sex-based discrimination against transgender people, right? Justices Sotomayor, Kagan, and Jackson call bullshit on this reasoning in their dissent. They say that SB 1, quote, plainly classifies on the basis of sex, and, quote, not only is the diagnosis of gender dysphoria itself defined by reference to a patient's sex, but Justice Sotomayor says that, quote, sex determines access to the covered medication. Physicians in Tennessee can prescribe hormones and puberty blockers to help a male child, but not a female child, look more like a boy, and to help a female child, but not a male child, look more like a girl, end quote. In Tennessee, under SB 1, if your kid expresses distress because they have unwanted facial hair, they can access hormone-based gender-affirming treatments to rid them of this facial hair if they were assigned female at birth, but not if they were assigned male at birth. Sure does seem like clear sex-based discrimination to me, too. But the court has decided, so what can we do next? As allies, we can offer love and support to trans friends and neighbors and families, and we should right now. We can be there when needed. We can ask how our friends and family members want and need to be supported. And a good first step can be to openly signal that you're a supporter of trans rights and to learn more about good allyship. And a lot of states have or are trying to implement laws similar to Tennessee's SB 1, so we need to keep fighting at the state and local levels when and where we can to pass laws and policies that protect and support trans kids and their families in every way we can, and also where possible, our medical professionals' rights to do their jobs. So thank you for listening. We hope it was helpful. We'll be back in your ears soon.